Contested defendants or they may be supporting defendants. In case if there are two persons, D and E, D is contested defendant and E, he accepts the version of the plaintiff. In that scenario, first of all, this E would cross-examine the plaintiff. E would cross-examine the plaintiff and thereafter D would cross-examine the plaintiff. For example, sometimes lawyers make mistake and D, the contesting defendant, he first cross-examine the plaintiffs. In that eventuality, if any admission is made against these persons, this supporting defendant F comes and he tries to overcome, he tries to undo those admissions caused in favor of supporting defendant. Make it sure that wherever there are more than two sets of defendants and one of them is supporting, then always insist before the court that first of all the supporting defendant should cross-examine the plaintiff as he is in league with the plaintiff, as he and the plaintiff have got the same assertion. Or order 6 and order 7, order 4, order 4, order 6 and order 7, these deal with order 6 deals with pleadings. In pleadings, both plain and written statements are included, whereas order 4 and order 7 they specifically deal with plaints. And besides these three orders, order 4, 5 and 6, section 26 CPC, it also deals with plaint. Plaint and suit. What is the difference between plaint and suit?
Sir, plaint is basically the document which we file in the court, and the whole thing we call suit, the process which initiates the court.
The process which initiates from the filing of the plaint till conclusion of the trial, it is known as suit. Suit includes both plaint and written statement. Suit includes plaint plus written statement. For example, when we say that the suit is fixed for evidence, it means the entire proceedings which includes plaint and written statement, we say that the suit is fixed for evidence. The word suit has not been defined in CPC, however this word has surfaced in several sections like section 9, section 10, section 11. It's a wider term which includes both plain, written statement and other proceedings which are initiated before the trial court, before the civil court. Presentation of a plaint. Every suit shall be instituted by the presentation of a plaint. A suit commences with the presentation of plaint before the court. A suit commences by presentation of the plaint before the court. In this plaint, it is either submitted directly before the court or other representative of the court nominated by the court. For example, in district court Shah, there is an institution branch and there is a person, institution branch. Whenever a person drafts his plaint, whenever a person drafts his plaint, he goes to the institution branch and the plaint is filed, submitted in that institution branch, and after scanning of the file, this file is sent to the court of senior civil judge judicial. There are two senior civil judges in courts. The first one is senior civil judge judicial, who deals with judicial work, and the second one is senior civil judge admin, who deals with administration of the judicial officers and staff of the judicial officer. So after institution of the case, when a case is filed between concerned person, reader of the court, thereafter, after scanning of the case file, the suit file, this file is sent to the court of senior civil judge judicial, and this judicial officer, senior civil judge judicial, he either keeps the case with himself or mark it to any other judge. And thereafter, the defendant is summoned, who appeared before the court and either contest or admits the version of the plaintiff. The first thing is section 26. It deals with institution of suit. And there is a famous saying, it is a centuries old saying that no one should be condemned unheard. Whenever a suit is instituted before the court, thereafter the suit is fixed for attendance of the defendant. The plaintiff files the suit, he is present before the court, but it is necessary to summon the defendant and call him to appear before the court. And for this section 27, summon to the defendant. After filing of the suit, the defendant is summoned, he appears before the court, and if he wants to contest the suit, he can contest the suit. The first section is section 26, and whenever the suit is filed, the defendant appears before the court and the process is issued under section 27. Section 27 deals with summons to defendants. This word summons, it is noun as well as verb summons. This is a singular noun summons, and for Urdu we use a word summon. In English we call it summons, and in Urdu we use the word summon for it. And the word summon means, summon is a document wherein the address of the defendant is written down and he is asked by the presiding officer, by the judge, to come before the court and defend himself if he wants to defend himself. What is summon? Summon is a document. Exactly, summon is a document whereby the court calls the concerned person, the defendant, to appear before the court and defend himself. And the plural of this word is summonses. Es is added with number of summons are issued against one defendant or more than one defendant, we call it summonses. Orders and rules, these are the procedural part of civil procedure code. And section D, this is the substantive part. So what's the difference between substantive and procedural part? Substantive part creates rights and liabilities of the parties, whereas the procedural part, it deals with procedure of the court, how rules and regulations are implemented in respect of a civil suit in the court of law. So section 26 deals with institution of plaint, whereas order 4 is the concern, is the correspondent order of section 26. Look at the first rule, suit to be commenced by plaint, and this was almost, these words were initiated in section 26. And thereafter in rule 2 it has been mentioned that a register is being kept by the court and all the fresh suits are entered in that register. That register is known as the register of suits, order 4 rule 2. दावा या जवाब दावा ड्राफ्ट करते हुए, लिखते हुए कौन से जनरल रूल्स है जो एक वकील के ज़हन में होने चाहिए कि दावा या जवाब दावा लिखते हुए ये जो बातें हैं, we should keep these factors in our mind while drafting plaint or written statement.
Written statement we will have to keep in mind for plaint the particulars given in order 7 rule 1. That is very clear. We can't deny the rule 1 of the order 7. That is, first of all, we will have to write the names, the addresses, the father name. That is on our assertions. Then we will have to see the jurisdiction, that where we file the suit, as the court has jurisdiction or not. And later on we will have to
Good. All have hit the nail on the head. The material points. The first, in order 6 rule 1, the word pleading has been defined and it refers that pleading means plaint or written statement. In order to it says that pleading must contain the material facts. Pleading must contain the material facts and it should not contain evidence or law. We are not supposed to discuss, write down evidence and law in the pleading. We are only bound to write down the material facts in our plaint or written statement. Only material facts are to be written down in the pleadings. exactly must be a concise statement, and how a plaint is drafted, how a written statement is drafted. हमारे जो दावा है, जवाब दावा, ये कैसा होना चाहिए, इसके लिए अगर आप देखें तो फॉर्म ए में उसको फॉर्म दिया गया है कि प्लेंट या रिटन स्टेटमेंट किस तरह ड्राफ्ट करनी चाहिए, प्लेंट या रिटन स्टेटमेंट किस तरह ड्राफ्ट करनी होगी। तो इसके लिए हमने फॉर्म ए में जाना होगा। फॉर्म ए में वो स्पेसिमेन है, आपको सिर्फ स्पेसिमेन दिया गया है कि ऊपर नेम ऑफ द कोड होगा, नेम ऑफ द पार्टी होगा, रेजिडेंस ऑफ द पार्टी, पेरेंटेज ऑफ द पार्टी, नेम, रेजिडेंस एंड पेरेंटेज ऑफ द डिफेंडेंट, ये होगा। ये जो स्पेसिमेन है ये फॉर्म ए में आपको मिल जाएगा। मटेरियल फैक्ट्स होने चाहिए। एक प्लेंट जो है इट मस्ट बी साइंड बाय द काउंसिल, क्लाइंट, plaintiff or his attorney. Plaint should be signed by the counsel of the plaintiff, by the plaintiff himself. If there are more than one plaintiff, any one of the plaintiffs or attorney of those plaintiffs. Also verified under order 6/15, and the verification is usually on oath. I would leave order 6/16.